Good afternoon. My name is Jeffany Roy, and I'm the senior attorney at the Farrell Law Firm. Here at the Farrell Firm, we focus largely on the practice area of family law. Family law includes divorce, custody, child support, adoption, legitimation, modifications, and a few other areas. I encourage you to check out our website at farrellfirm.com and to follow our Facebook page. Before we get started, please note that all information given today is for informational purposes only. Every person and every case is different and requires specific legal advice. If you are in need of legal advice, you should contact a lawyer, ideally us here at the Farrell Firm, and schedule a consultation. By tuning into this broadcast, you acknowledge that you understand that the information given today does not create an attorney-client privilege. Now let's get into why you came here today. Child support. And please type questions as I go along, because at the end, I'm going to answer each and every question. Last week, Attorney Farrell presented you guys with some great information around child support. Just in case you missed it, I encourage you to go back and check it out. But here is a quick overview. What is child support? Child support is the financial support obligation paid for the support of a minor child. It is calculated using gross income of both parents. Prior to 2007, child support was calculated using only the income of the non-custodial parent. So if you have an order from 2007 or older, you want to modify that. Since 2007, child support is now being calculated using the income not the $3,500 or so that you bring home each month. There are a lot of things that can make up your gross income. Your regular job paycheck, commission and tips, self-employment income, bonuses, overtime pay, disability benefits, retirement income, unemployment income, lottery income, and some other areas. All of these things can be considered, and even where there is no income, it can still be imputed. The courts can impute income to your earning history or your earning potential. So if you are unemployed now, but used to make $40,000, the court could enter child support using $40,000 as income. Zero cannot be entered as income into the child support worksheet. The minimum amount of income that can be entered is $1,261.50. That is full-time minimum wage income for 1 month. So let's talk more about child support. We will address deviations, modifications, and contempt actions today. Child support deviations. There are two types. Once numbers are placed into the child support worksheet, a presumptive amount of child support is calculated, meaning this is the amount one is presumed to pay. However, there are two types of child support deviations that may alter this presumption. The first type is mandatory deviations. Mandatory deviations must be taken into account during the child support calculation if they are applicable. There are two types of mandatory deviations. The first one is work-related child care expenses deviation, and the second one is the healthcare premium deviation. These two deviations take into account the yearly amount that each parent expends on work-related child care and health insurance premiums for the children involved. The other deviation type is non-mandatory or discretionary deviations. In addition to the mandatory health insurance and work-related child care costs, mandatory deviations, there are several other non-mandatory deviations that may increase or decrease the presumptive amount of child support. These deviations may include, but are not limited to, high income, low income, other health-related insurance, life insurance, alimony, mortgage, extraordinary expenses, parenting time, and non-specific deviations. Let's talk about these. If the parents make over $30,000 a month combined, they are considered to be high income, and the child support amount may deviate higher than the presumptive amount. To be granted a low income deviation, a parent must show that he or she has no earning capacity, or that the presumptive amount of child support would create an extreme economic hardship for him or her. If granted, the minimum amount of child support must be paid is $100 per month and will vary depending on the number of children. A parenting time deviation is based on the non-custodial parent's visitation time with the child. This is typically for non-custodial parents who exercise frequent visitation, more than every other weekend schedule. Parenting time deviations are great for parents who share joint physical custody. Travel expenses. If the non-custodial parent must travel to exercise parenting time, he or she may seek a downward deviation to their presumptive child support amount to ensure that parents are not hampered from exercising parenting time due to financial constraints. Child support deviations for mortgage or rent. Essentially, this deviation allows a non-custodial parent who pays for the residence where the minor child and the custodial parent reside. That parent may reduce his or her final child support obligation. Depending on the circumstances of the specific matter, the non-custodial parent may seek a deviation amounting to the total cost of the mortgage paid, or only seek a deviation for a portion of the amount paid. Non-specific deviations. This deviation is essentially a catch-all category that was included to cover certain family-specific or special situations that may not be adequately addressed by any other deviation. Because every family is unique, what applies in one family may not apply in another. With the non-specific deviation, the non-custodial parent has the ability to ask for a deviation for any reason. Any deviation granted must serve the best interest of the child. And these deviations that are non-mandatory are at the discretion of the judge. Now let's talk about modifications. In order for a parent to seek the modification of a prior child support award, he or she must allege and show that there has been a change in the income or financial status of either former spouse or in the needs of the minor child or children. Income may change from job loss or job promotion. You should not modify based on minimal changes. The legal statute is looking for a 25% change in the income before seeking a modification. That's a 25% change upward or downward. The needs of the kids may change. For example, the child may now be school age and no longer need daycare full-time. A child may become ill and need substantial medical care. Or for example, a child may need special tutoring that was not needed in the initial action. Child support modifications must be a court order. The biggest mistake people make is when they come to an informal agreement to modify child support. In order for child support to be modified, it must be done by a court order. This is for your protection. If you informally modify outside of the court, you are still on the hook for the original amount of child support. So for example, if you pay $750 per month in child support, but you come to an agreement with the custodial parent that you can now just pay $500 per month. You do that for 3 years based on the agreement. You and the custodial parent have a disagreement and they go file a contempt action for $9,000 that you haven't paid since your child support obligation was $250 short for the last 3 years. You will be completely responsible for paying that $9,000. This leads me to discuss contempt. Child support contempt. If there is a child support order in place and it is not being paid per the terms of the order, meaning it's not being paid on time, it isn't being paid in full, or at all, you need to file a contempt action. You need to let the court know that an order is not being followed. Don't wait for child support services to get around to it. You have the right to pursue any support not being received. There is no threshold for how far behind someone has to be on payments for you to file a contempt action. If you are the one in contempt of the child support payments, you need to do everything possible to bring yourself in compliance. Failure to do so will result in serious consequences. If you cannot afford the child support, then you need to see if you qualify for a modification. Be proactive about this. Don't wait until the last minute. Don't wait until you're in arrears in the hundreds of thousands. Be proactive and try to modify early. I think this is enough information for today. So please ask questions and I will answer them for you live now. So while you guys are typing your questions, I do want to note that for those who are catching this broadcast later, it may appear live to you, but it won't actually be live. I won't actually see your questions. If it is not Friday, June 9th, between 1 p.m. and 1:30 p.m., you are not live. However, type your question and we will come back and try to answer them at a later time. Now let's go to our first question. Our first question is from Oscar Dale Roy. My ex wants daycare fees on top of child support, but daycare is not necessary. Do I have to pay them? If the daycare is work-related expenses, meaning mom or dad is going to work and the child must go to daycare during that time, then it is a necessity and may be calculated in the child support worksheet. If mom is sending the child to daycare or dad is sending the child to daycare and staying home or running errands because they are unemployed, then daycare is not necessary and therefore it will not be calculated in the child support worksheet. Another question from Oscar. My ex wants daycare fees on top of child support, but daycare is not necessary. Do I have to pay them? I think I just answered that question previously, so you can watch the broadcast to see the answer for that. Hannah, your question. If my ex got a big raise at work, but we just finalized our support order before the raise happened, can I go back and modify immediately, or do I have to wait since we just finalized it? Depending on how big of a raise it is, as I previously said, it has to be more than 25% of what they were already making in order for the modification to take place. If that is the case, then you can modify immediately. If it's not more than a 25% increase, then you must wait the statutory time, which is 2 years through a private attorney or 3 years through child support services. Question from Alex Gaines. What if we have a written agreement to change child support and custody? Does it have to be signed by the court? In order for it to be enforced by the court, it does need to be signed by the court. Otherwise, it is an informal agreement. No one has to follow that agreement. If she or he decides not to abide by it, it cannot be enforced. So I always encourage any handwritten, any informal agreement to be signed through the courts. Question from Alicia. If I'm paying my child support as the judge ordered, but sometimes the other parent needs money right away, so I give it to them, can I get credit on my account for this? While I suggest co-parenting and doing what's best for your children is always at the forefront, if you're going to give money outside of child support, it needs to be something that can be traced. A money order, a transfer to the account, a check, something that can give you credit should it not be credited to your account later. So for instance, if your child support order is $500 and your other co-parent needs an additional $100 and they need it today, and you have an income deduction order for $250 every other week coming out of your check, and you give an extra $100, you want to make that in the form of a money order or a check, and you want to note that it is for child support. Otherwise, it would be considered a gift. Jennifer, thank you. That was a compliment, not a question. Thank you, Jennifer. I appreciate it. So type your questions. I will wait a few more minutes. Here's another question. My ex was working a full-time job and making decent money, but when she decided to have another child, so she quit her job and stays at home. Do I have to pay her more now because she decided she wanted to quit her job? If she has a live-in boyfriend who paid all of the bills, will that be taken into consideration as her income? So for child support purposes, if someone voluntarily quits their job, usually what the courts do is impute their income to what they were previously making. So if she quit her job and she was making $40,000 or he was making $40,000 and then quit the job, that $40,000 can be imputed to them, although they are still unemployed because they quit their job. If they were terminated, then we would be talking about something else. It is likely that it could still be imputed to $40,000, but may not be. It is really discretionary at that point. Got a question here for Ambica Boyd. How to prove that someone submitted a false W-2 to prove a lower income to have reduced child support payments. There are several ways that that can be handled. Unfortunately, if you are going through child support services, they're not going to do any discovery or anything that would notify them that the W-2 was false. If you're dealing with someone like this, it is always best to go through a private attorney. That way we can do discovery, we can subpoena records, we can request records, pay stubs, and the W-2 that was falsified, we can request the W-2 from the real company. If it's not a real company, that will be up for discussion as well. Income can be imputed based on earning history, earning potential, bank records, credit card statements. Lifestyle can be considered when we're talking about child support and imputing income, because we do have a lot of people that operate cash businesses or they don't keep good books. And so we have to look at other things to kind of make the argument that they have a lifestyle that's not, that doesn't look like they make minimum wage. So those types of things probably should be handled through a private attorney. That question prompted something that I was discussing with our staff earlier today. Child support services. Please understand that child support services is an enforcement agency. They are not the person or people that puts out these child support orders. In other words, there has to be a child support order from a superior court judge that is signed before child support enforcement can get involved. So if you have a non-custodial parent or a custodial parent that says, hey, I've closed my child support case, you don't owe me any child support, closing a child support enforcement case does not cease your child support obligation. Your child support obligation will continue month to month, whether it's being enforced by child support services or not. So please know that child support services is an enforcement agency. They cannot stop a child support order, nor can they enter a child support order on their own. All child support service orders come from a superior court judge, either from a legitimation, a divorce, a modification, establishment of child support. That all comes from a court order first, and then it's handled for enforcement purposes by child support services. We have another question. It says, can I modify one child support case to be lowered so I can afford the second case? You can modify the first child support order and have the court take into consideration that you now have a second child. You may not get the full credit for your second child because public policy says that the only cases that get credit are the pre-existing child support orders. For instance, you have one child, you're ordered to pay $500. For your second child, when that child support calculation is being done, you are supposed to get credit for the $500 that you were already ordered to pay. So that way you consider the first child and the second child, and then the second child will get whatever the worksheet pulls. It cannot be reversed. So if you have a second child that requires child care expenses, and you have to pay support, and there's a child support order, you can't then say, well, lower my first child support order so I can take care of my second child. That goes against public policy, because what the courts have said and what legislation has said is that if you continue to have children, you know that you have other children first that you already have to take care of. Another question from Tanisha. Do I need an attorney to file for the contempt for non-payment, or is that something I can do through the courts on my own? Side note, the non-custodial parent does not live in Georgia. For a contempt, if the non-custodial parent does not live in Georgia, if you have a Georgia order, meaning you have a court order that was issued in Georgia, one of the counties in Georgia, you can file contempt in that court where it was issued. You do have to serve the non-custodial parent wherever they are before anything can move forward with that contempt. And it is something that you can do on your own. However, I would advise against that because there are a lot of things that come into play. We're talking about venue, jurisdiction, and you have to know the proper legal qualifications for the contempt and what you're looking for and what it has to be in order for it to be a true contempt action. Question from Jennifer. Our agreement states that we do not owe each other child support. If one person transfers money on a regular basis, does this mean it can be used in court to say that was a pattern of behavior and now established as support payment? Basically, can it be used against the person who transferred the money to say, now, how does the court view this? If there is no order to pay child support, then because somebody is transferring money on a regular basis, that would be considered a gift to the courts because there's no child support order to comply with. It's viewed as a gift and won't be taken into consideration unless we're talking about income for the person that's on the receiving end of that gift. Consistent gifts can be considered as income for child support calculation purposes. So also be mindful of that. But the actual transfer, if there's no court order, those are considered gifts. If my ex moved to another state, but I am still in Georgia, can they modify the child support in the new state? Usually when you want to modify something or change something, you have to file in the county and state of the defendant. And it also will matter, because it's child support, it matters where the child resides. So that is a loaded question. So there are a lot of variations that can go into the answer, but essentially you have to file in the state where the parent or the defendant resides, and then you would go from there. Question from Ty Hawkins. My ex-wife has physical custody of our kids per our divorce decree. However, we share legal joint custody. I've had physical custody since October of 2016 from an agreement her and I signed and got notarized. She has not given me any financial support in over a month. Can I file abandonment? No. Your wife, according to the court order, has physical custody of your children. What you should do is file a modification of custody based on the fact that the children now reside with you and have been residing with you since October of 2016. Now is the perfect time to file for modification. You do have to file in her county of residence. You need to file as soon as possible so that you can change the physical custody arrangement and get a child support order that pays you rather than you pay her. From Jerron Martin, I currently pay child support for three children to my ex. I have a baby on the way with my fiance and will be adopting her son as well. Can I get my child support lowered when that happens? I also pay all the medical bills as well. It depends on what your current child support order is. Were you given credit for paying the health insurance premium, or are you paying all of the uninsured medical expenses? Also, if you're going to adopt your fiance's son and you have a baby on the way, that will or can be taken into consideration, but it will not go on the worksheet as a pre-existing obligation. It's basically a credit that you receive where your children live in the home with you, and there are a lot of variations to that. For that situation, I would definitely hire a private attorney because we can do things like theoretical worksheets, which gets a little more in-depth to child support, but we can ask the judge to look at what it actually costs to raise a child living in your home. And so that can be taken into consideration. So you want to definitely seek out a family law attorney to take care of that for you. Another question, how do you prove that the parent is not spending time with the children during visits? The child is being taken care of by a grandparent, taken to school, meal prep, etc. Basically, you would need some pictures or a statement from the grandparent, and just making the assertion itself. If he's working during the time he's supposed to have the children, then you can note his work schedule. Just a number of various ways. Sometimes you have to get into private investigator mode to kind of prove these things. But if the custodial parent or non-custodial parent is not the one actually spending time with the children during the majority of the visits, because sometimes both parents need, a date night or a getaway, and it's okay that they have a babysitter or they let grandma or grandpa keep the child. But if it is the majority of the time and it's a consistent thing that they just get the child and leave the child with some third party, then you most certainly want to discuss that, because that may warrant a modification in child support. Does legitimizing myself joint custody and credit for time spent, will that lower my child support payments? Legitimation gives you custodial rights, parenting time schedules. It doesn't necessarily lower your child support payments unless you have a lot of parenting time. And we did a video a few weeks ago about legitimation, so you may want to go and review that because we answered that question in that as well. Joint custody, if you're talking about physical custody, that could lower your child support payments. If the child is school age, the judges may or may not go with the joint physical plan because typically they don't like children living out of a suitcase. What if the child support order was done in Washington, but we both now live in Georgia? Do I have to go all the way back to Washington to file the contempt, or can I file it in Georgia since that's where we live now? In a situation like this, you want to take that Washington order and you want to domesticate it here in Georgia so that it becomes a Georgia order. If you do that, then you can file the contempt here in Georgia. But typically it is where the court order is originated. The way to get around that is to domesticate it here in Georgia and have a Georgia court enforce it. Another question from Tara Cadogan. If my husband has been a part of my daughter's life for nearly 8 years, although he has not adopted her, he has been the only father she knows. Is there a law that sees him as her father? No, there is not. He would need to adopt her. If something were to happen to you right now, if the biological father is alive, he would be the next in line to get your daughter if something were to happen to you. If he has not legitimated your daughter and we don't know where he is, or he's not active in her life, then essentially what you select in your will as her guardian would take precedent, but that's a sticky area as well. The only way that he would have a legal resolve is to actually adopt your daughter. And step parent adoption is it's a very good thing when we have kids and we have previous children from previous relationships. It's something that a lot of parents have done. We've done a few of those in our office. It's something that we love to see. I paid child support, but my son's mother will not allow me to see him because she said it don't fit her schedule. So this is a situation about legitimation. Was your son born in wedlock or out of wedlock? Because that matters on where you stand with your custodial rights or your visitation. If your son was born out of wedlock, child support does not equal visitation. If you want to get a parenting time schedule or a visitation schedule and establish yourself as the legal father, you will need to file legitimation here in Georgia. Okay, I'm going to answer a few more questions live. Question from Latanya. My ex-husband lives in Mississippi. He has not paid child support since 2008. He has a legitimate job. How has he avoided paying support? He's over $50K in arrears. Do you have a child support order? Is it being enforced through child support services? What state is it in? Have you made contact with the state? Have you filed contempt in the state, wherever the order is? So there's a lot of questions that I would have to ask in order to give you a proper answer to your question, Ms. Johnson Stanford. And so you may want to consider filing or asking for a consultation with our office. Our consultations are $150. It gives you up to an hour with one of the attorneys in the office, and we will most certainly be able to address this question for you more in detail. Question from Shanika Tompkins. My children's father owes $9,000 in back support and currently not paying anything. There is a court order through child support services. However, he quit his job and does so about every 6 months to avoid paying. He is enrolled in the fatherhood program, and I was told that due to this, they won't enforce the court order. Is there anything that I can do? Most certainly, you can file a contempt action through the Superior Court in the county where the original court order was issued. So Child Support Services has the court order. They did not issue the court order. So whatever county that was issued from, you can file a contempt privately and ask for that $9,000 to be paid back lump sum, at a monthly rate, and how it's paid back will be determined by the judge. Okay, so I'm getting ready to sign off. Thank you all for tuning in today and for asking these great questions. We do offer 1-hour consultations here at the Farrell Firm and encourage you to schedule an appointment if you have legal concerns. Consultations are $150. Please like our Facebook page and follow us. Check out our website for more information about the firm. I hope you have a blessed weekend.